Professional responsibility examples outline. So when a lawyer's client walks in and they have liability insurance, who's the lawyer's client? The policyholder or the insurance company? The majority rule is that the client is the policyholder. The minority rule is that the client is both the insurer and the insured, so long as there's no conflicts between the insurance company and the policyholder. If there is a conflict, the duty is to the policyholder, right? The person that walked into your office, got your services. So at the time of Zimmerman, this is about Zimmerman earlier, there's no 1.6B1 exception that you can disclose to save someone's life. So just know that's changed. So Zimmerman would have been decided differently today. Two, the lawyer's duties to protect client information and confidences, three doctrines. So there's professional rules, that's the duty of confidentiality. There's the rules of evidence that give us the attorney-client privilege, and there's the rules of procedure that give us the work product doctrine. So attorney-client privilege you can only assert during lawsuits, and work product doctrine, also can only assert during a proceeding. The duty of confidentiality always exists. So a sliding class duty of confidentiality is everything, all information relating to representation of a client, right? Like client communications, lawyer's observations, lawyer's prepared materials, information from other sources. Within that, subset of that is attorney-client privilege. That comes from the rules of evidence. You only assert it during a lawsuit. There's the 5 C's for when it's protected by attorney-client privileges. When the client confidentially communicates with counsel to obtain counsel. Client confidentially communicates with counsel to obtain counsel. That's attorney-client privilege. Work product doctrine. Another subset of 1.6 comes from rules of procedure. Only can be asserted during proceedings. The lawyer's materials made in preparation for trial or anticipation of litigation. So intersection of attorney-client privilege and work product doctrine, work done in preparation of litigation that contains confidential information. So I'm not going to talk about 1.6. Technically, everything here violates 1.6 in this example with like you're talking about what you've done. But everyone talks about it a little bit. So we talk about there has to be some reasonable line of what you're allowed to say. So first off, there's a comment that you can talk in hypotheticals if they're not going to if the other party isn't going to figure out your client. Restatement 60, comment C says you can discuss a client's identity and identifying information so long as it doesn't adversely affect the client's interest. But if the client tells you not to disclose their identity, then don't disclose their identity. So technically saying anything is going to violate 1.6A, but restatement 60, comment C generally gives a more realistic way the law works. Like just, really be general and don't say anything that's going to harm your client. And if they tell you not to tell anyone, then you can't tell anyone. Anyway, exceptions to model rule 1.6. Right, we got 1.6B1. It's may, discretionary may, when you may disclose things. To disclose, you can disclose to prevent death or substantially bodily injury. Model rules, it's may. In Illinois, it's mandatory shall, but just know that. Difference between B2 and B3. B2 involves when you report before the crime and fraud. B3 involves the lawyer reports after crime and fraud. The crime fraud is still happening, and the lawyer is trying to mitigate the harm to the victim. So problem 4.2, remember that's the example of finding the victim's body. You represent the criminal defendant. Remember, everything in 1.6B is discretionary. So if the lawyer says nothing to authorities, then the lawyer has technically complied with the model rules. Would you tell the parents? There's no right answer. What would you do if the killer escapes? So of course you tell the police about what happens. This falls under the 1.6B1 exception here. Professor makes a point to say you do still have a duty, 1.6 duty of confidentiality here. Nothing would allow you to disclose past crimes, but you would be okay to disclose possible hideout if you thought it would prevent a future crime, right? Prevent him from being able to harm his hit list. Problem 4.6, just wait, caught versus not caught, and those monetary outcomes, take the weighted average and you'll get an answer to the ethical problem, but nothing requires you to disclose since 1.6B is discretionary. But fraud is still ongoing because the leases are still being financed. The leasing company has become a fraudulent enterprise. So the point of this is to point out in 4.1B, which says that you must disclose a fact if failure to disclose a fact will assist with a client to continue with a crime or fraud. You must disclose if failing to disclose will allow a crime or fraud to continue. Model Rule 1.6B and 4.1B go together to say that there are some situations where lawyers must disclose client fraudulent conduct. 1.2, comment 10, noisy withdrawal, let the client, bank, etc. know that you're withdrawing, and you disaffirm any opinions, representations in the past that should not be relied upon. That's going to set off alarm bells. People are going to be able to protect themselves. Moving on to the attorney-client privilege. This comes from the rule of evidence. It attaches when the 5Cs happen. The client communicates confidentially with counsel to obtain counsel. Client, obviously, it's prospective client, current client, or former client. Communicates voice, email, letter, phone call, text, anything. Confidentiality. Client has taken reasonable measures to ensure secrecy of the communication. Counsel, it's a lawyer, the lawyer's agent, paralegal, the lawyer's firm, the lawyer's secretary, etc. Counsel just means advice, right? When the client communicates confidentially with counsel to obtain counsel. Exception to the attorney-client privilege is if the client waives the privilege, or the crime fraud exception, client is seeking advice to further engage a crime or fraud. In Upjohn, the purpose of attorney-client privilege is to promote full and frank communication between lawyer and client. It serves the public interest. That's where the attorney-client privilege comes from. Also obvious, but attorney-client privilege protects lawyers' communications to client and vice versa. Hypothetical A, you're representing defendant in defendant lawsuit involves a car accident. What should you do? In these hypotheticals in 2C, we're going to go to that. Please hold. So during a private meeting in your office, driver tells you I ran through the red light. That's protected by attorney-client privilege. Number 2, plaintiff lawyer asks the defendant driver, your client, did your lawyer ever tell you you'd be liable if you ran over red light? Objection, attorney-client privilege. 3, same facts. Number 1, the lawyer asks defendant driver client, did you run through the red light? Facts aren't protected by attorney-client privilege, but what the client saw or learned or heard before talking to the lawyer, that can't be protected by attorney-client privilege. That's the point of that. So you, the defense lawyer, are being deposed before the trial of your defendant driver client. In the deposition, the plaintiff lawyer asks you, did your client tell you that she ran through the red light? For that, you say objection, attorney-client privilege. Same facts at number 4, the lawyer asks you, the defense lawyer, did your client run the red light? For that, the privilege applies here, but it can get the substance of the communications between the lawyer and client. But you just say, I don't know, I wasn't there. That's a better way to approach it. Number 6, as part of the pretrial investigation, driver's case, you were interviewed an eyewitness the accident, named a witness who told you your client ran the red light. Local newspaper reporter calls you and says, I know you talked to Irma. What did they tell you? You don't have to respond to that. You just say goodbye, click. But it wouldn't be attorney-client privilege. It would just be duty of confidentiality. That's what the point of that is, to draw it. So when your client is an organization, attorney-client privilege protects conversations with employees and lawyers. The old rule, which is rejected now, is a control group test. Attorney-client privilege would protect communications between the lawyers and the control group, i.e. people in the position to control the organization. But Upjohn rejects the control group test. The new rule from Upjohn is attorney-client privilege applied here rather than the 1.6 duty of confidentiality, because this is a formal investigation in a proceeding. 315 has a list of times to assert the privilege. There's no bright line rule from Upjohn for when the employee is protected by attorney-client privilege. Instead, the court gives a bunch of facts and specific observations, such as like when it's requested by the company's attorney, the info is not available to the upper chain of management, communication concerns matters with the lower level employees' job duties, employees were aware they're being questioned, so the company couldn't obtain legal advice. Request for info was accompanied by legal advice provided to lower employees. Chairman explicitly directed communications as highly confidential. Communications were kept confidential by the corporation. This isn't a checklist, just a thing of factors to consider. So for hypothetical B, that we talked about, the attorney in each of the following scenarios is an in-house lawyer, the Upjohn company. Can the lawyer on behalf of Upjohn claim attorney-client privilege to protect the lawyer's communications with the described person? An Upjohn truck driver employee had a traffic accident while operating the company truck on his own time. Truck driver goes to Upjohn in-house lawyer to admit he consumed several beverages before. No, it's not protected because you're not the driver's lawyer, you're the company's lawyer. I say it's probably, for number 2, another Upjohn truck driver, while loading his truck at Upjohn, saw an Upjohn purchasing manager hand a big stack of $20 bills to a customer's agent. The truck driver has no responsibilities related to purchasing, but the exchange of cash looks suspicious to him. On his own initiative, the truck driver tells his suspicions to Upjohn's in-house counsel. Professor Cordick says it's probably privileged under Upjohn. Professor Cordick says it turns on whether this is communication being privileged consistent with Upjohn. Cordic says most holdings this communication is privileged. So you can waive for waiver of privilege. You can waive attorney-client privilege a few ways. One, there's an intentional waiver, like the client just tells a third party about the substance, or an unintentional waiver with third party, non-client hears a communication, or you put the substance of the attorney-client communication at issue. Typically see this in cases where lawyers are sued for malpractice. Another typical example, you're a criminal defendant and say, I thought this was legal since my lawyer said it was legal. That puts attorney-client communication at issue. You can't selectively waive attorney-client privilege. You can't waive one sentence of an email or something and keep the rest secret. So once you disclose a small part of the communication, the rest is privilege. You can't selectively waive the recipient of the attorney-client privilege, so the client can't just tell their mom to keep the communication secret to everyone else. If you waive to one person, you waive to the whole world. All right, so moving on to the next hypos. Waiver of attorney-client privilege. Well, okay, so client comes to your office seeking legal advice. She tells you, last night I smashed a window with my neighbor's car and baseball bat because the car alarm went off at 3 a.m. Nobody knows it was me. What should I do? Is your conversation with the client protected by attorney-client privilege? It's not an ongoing crime, so it's protected. Attorney-client privilege protects past completed crime. Past completed crimes are always protected by attorney-client privilege. Hypothetical B. Client comes to your office seeking legal advice. She tells you, I employ a full nanny to care for my children. I pay her in cash, not withhold taxes, blah, blah, blah. Yes, this is an ongoing fraud, so communications are not protected. But if you as the lawyer say, hey, this is tax evasion, you're breaking the law, this is how you can pay and become current on your taxes, the client agrees, then it's arguably protected by attorney-client privilege. But unless that happens, it's an ongoing fraud. It's not protected by attorney-client privilege. C. Your client, Monica Lewinsky, was subpoenaed to testify at a deposition of Paula Jones, harassment of Bill Clinton. Lewinsky asked for help to avoid the deposition. You prepare a memo to quash the subpoena and drafted an affidavit, which, under penalty of perjury, Lewinsky stated, I never had sexual relations with that man. Court that after quash the subpoena, Lewinsky avoided being deposed. Several months later, you have been subpoenaed to testify about your conversations with Lewinsky relating to her earlier filed affidavit relying on attorney-client privilege. You have moved to quash the subpoena against you. The Office of Independent Counsel asserts the crime fraud exception to the attorney-client privilege wipes out any claim of privilege. Is the crime fraud exception available here? How should the court rule on your claim of attorney-client privilege? No attorney-client privilege doesn't help because the crime fraud here is committing perjury, so communications related to that won't apply. Professor Cordic says it doesn't matter whether the lawyer knew about the ongoing crime or fraud. Regardless of the lawyer's level of knowledge, there won't be attorney-client privilege when the client is using attorneys to further crime or fraud. This makes sense because the attorney-client privilege belongs to the client, so when the client using the attorney to further the crime or fraud, then it makes sense the client would lose that privilege. Work product doctrine, it comes from the Federal Rules of Civil Procedure. Notes, recordings, memos, conversations between attorney and client privilege are protected under the work product doctrine. Work product doctrine flowchart says documents, materials prepared by the lawyer or agent in the course of representing a client, protected by the doctrine. Work product prepared in preparation or trial or anticipation of litigation. And what's not protected, all other work products. So under protected by work product doctrine, there's opinion work product. That's materials containing or reflecting mental impressions, conclusions, legal theories of an attorney concerning litigation. That gets the highest protection. The court will order disclosure only if the opponents show extreme necessity in getting the materials. But there's fact work product. It says all work product materials prepared by the lawyer in preparation for the trial or in anticipation of litigation. Protection, disclosure only if opponent shows a substantial need for the materials and unable to, without undue hardship, to obtain substantial equivalent of the materials or other means. There's two levels of work product. There's the highest protection, that's opinion work product, and there's disclosure only of substantial need and unable to get the facts without undue hardship, and applies only to fact work product. That's the lower level, but highest protection is opinion work product. Upjohn questionnaires were probably highlighted notes margins, so the questionnaires in that case were probably protected as opinion work product rather than just fact work product. Self-regulation of lawyers. So who regulates lawyers? The state Supreme Court adopts professional rules, enforces the rules, bar admissions. Interesting for character and fitness, no presumption of moral character. The burden is on the applicant to show they are fit by clear and convincing evidence. You have to pass using clear and convincing evidence. We'll just skip that problem. Clinton exercise. duty to report professional misconduct. You are required to report other lawyers' misconduct. In re Himmel, the facts, the court went after Himmel for failing to report other lawyers' misconduct. The holding, the court said Himmel was compounding a crime when he promised not to prosecute the other party in the settlement. So hypo for 8.3. Let's see what that is. So 8.3 hypotheticals. And just as a reminder, Rule 8.3 is reporting professional misconduct. So, hypothetical one, you and another associate from your firm are working on document production in a court case. You see other associates shred documents from the client's file. These are documents that both you understand must be produced to your opponent under a court order. Hypothetical two, you're at a social event hosted by, answer to that is yes, it's violation, report under 8.4b. We skip number two. Hypothetical three, you're at a federal courthouse waiting in the hallway, the case to be called by the judge. You overhear two other lawyers whom you recognize speaking in the hallway. One other judge says the other, I'm glad, or one other lawyer says the other, I'm glad we showed those documents. There's no way we could turn over such damaging stuff even though the court ordered us to do so. Thanks for making that stuff disappear. Yes, this is a violation of 8.4b, C, and D, so you have sufficient knowledge of misconduct. You got to report that. 8.4, client comes to you for legal representation. The client tells you that a prior lawyer shredded documents that should have been produced in discovery in a court order. Yes, it's a violation. After the client's interests have been safeguarded, since reporting will obviously harm the client's interests. So 5, hypothetical 5. Client who's a lawyer seeks your legal advice because, as she tells you, she herself improperly shredded documents in another case, documents that should have been produced in discovery. No, don't report this. Is protected under 1.6 duty of confidentiality. Since it happened in the past and it's not ongoing, you don't have to disclose information otherwise protected by 1.6, but 3.3c says you have a duty of candor towards the tribunal. It takes precedent over 1.6, so it's a weird tension there. Intra-firm organization regulation. So to be disciplined under 5.1c, a lawyer knows or ratifies the conduct. So if the supervisor really doesn't know the wrongdoing or ratify it, then the lawyer hasn't violated 5.1c. Subordinate lawyers is 5.2. You're on the hook for your own conduct, but there's a safe harbor in 5.2b. Subordinate lawyers does not violate the rules if the supervisor lawyer acts in accordance with a supervisory lawyer's reasonable resolution of an arguable question of professional duty. So for 5.2 safe harbor, subordinate lawyer is going to have to raise the ethical violation. The partner is going to have to give a reasonable explanation. So Bohatch versus Butler and Binion. The facts of that case, one partner reported another. For bilking, reported partner was fired. The holding is that the partners of that firm owed no duty not to expel their partner for whistleblowing the other partner. Most states, lawyers that are related against for reporting wrongdoing don't have a cause of action against their law firm. Justification of this is that they're at-will employees. Multi-jurisdictional practice of law, 5.5c is new. Let's pull up those hypotheticals. So in this one, all right. So hypotheticals. You're licensed in Illinois. You've not been admitted. Oh, you're licensed in Illinois, Northern District of Illinois, Court of Appeals for Seventh Circuit, and SCOTUS. Client is a large financial services company with headquarters in Connecticut, offices in all 50 states. Which of the following, if any, would violate current rule of 5.5? Yes. So number one, a disgruntled investor sues your client in Northern District of Illinois, alleging securities fraud. Can you represent your client in this federal securities action? Yes, obviously licensed in jurisdiction. And then two, what if the lawsuit also includes a claim for non-common law fraud and negligence under Connecticut state law? You can represent on this claim too, since you represent the client for any matter in a court where you're licensed to practice. 5.5c2. Once you're licensed to practice in court, you can represent a client with respect to any claim brought that court, other claims based on state law, federal law, other state law, other laws. We're going to add 5.5. Oh, we did. Cool. Number two, Key witness in federal securities action lives in South Carolina. Can you go to South Carolina to depose the witness in South Carolina? Yes, you can do this under 5.5C1 and or 5.5C2. It's reasonably related to the proceeding in Northern District of Illinois where you are licensed, so that's fine. This is not that bad. 3, if you travel to the client's headquarters in Connecticut to discuss litigation strategy with the general counsel located there, are you engaging in unauthorized practice of law in California or Connecticut? Yes, is still allowed under 5.5C2. It's reasonably related to a proceeding in Northern District of Illinois where you are licensed, but in the Burbauer case held that you'd be practicing law in both Illinois and Connecticut. Keep that in mind. You are practicing both Illinois and Connecticut, but it's allowed under 5.5C2. Stay home in your Chicago office and instead telephone your client Connecticut office to discuss strategy. Are you engaged in practice of law in Illinois and Connecticut or both? Yes, it's allowed under 5.5C2 since it's reasonably related to a proceeding in Northern District of Illinois. So note you would need Connecticut to enact the new 5.5C2 since you're perfectly allowed to practice in Illinois, but you'd only be practicing in Connecticut where it would be a problem. Under 5, you're spending a long weekend at your home in Wisconsin. While in Wisconsin, you telephone the client in Connecticut to discuss the case in Chicago. So same answer is still allowed under 5.5C2. You're practicing law in Wisconsin and Connecticut. Same analysis number 4. So you need both Wisconsin and Connecticut to pass the new 5.5C2, where it's reasonably related to a pending and a jurisdiction that you're allowed. The same Connecticut client has also been sued in similar investment fraud case in Texas state court brought by a different unhappy investor from Texas. Can you please represent your client in the Texas, or can you represent your client in the Texas state court action? It's not allowed to do this right away. You need to have Texas court to meet pro hoc vice for the limited purposes of this case. Federal courts tend to be pretty liberal with allowing pro hoc vice representation. Connecticut-based client wants you to acquire another company based in Florida. The transaction will be governed by the law of Delaware. Working on this deal will require you to spend substantial time in both Florida, where the target company is located, Connecticut, where your client is based. You can do the necessary work in those 2 states. 5.5C4 is applicable here since the merger is reasonably related to the practice of law in Illinois. Professor Cordick says comment 14, page 95 may be enough to make this work. Okay, as an Illinois lawyer helping Connecticut client, Florida deal, Delaware choice of law. And comment 14 is that a variety of factors include, your past relationship with the client, whatever, blah, blah, blah. All this work in Connecticut, you lawyers set up a satellite office in Connecticut for your convenience. 5.5D was not violated here since it's not continuous and systematic presence. Cordick says this temporary satellite office is usually okay under 5.5. Also under 5.5B, the office must be systemic and continuously violating 5.5B. So since the office is truly temporary, it's probably allowable under 5.5B. For 9, you decide to take a job as general counsel in Orlando, Florida. Do you have to take and pass the Florida bar? No, because under 5.5D1, you would not need to take Florida bar. You could practice in Florida using an Illinois license so long as you provide legal services for the employer, in-house counsel working at Disney. Can you appear in Florida court on behalf of your client? 5.5D1 specifically says you need pro hoc vice admission to appear in court on behalf of your client. So Ms. Hypo, Illinois lawyer, would do in-house work in Florida, but you'd still need pro hoc vice admission to appear in Florida court on behalf of Disney. 5.5D1, nothing authorized Illinois lawyer to do pro bono work in Florida. Can you do pro bono work in Florida for indignant clients who cannot afford it? Nothing authorized Illinois lawyer to do pro bono work in Florida, but 5.5D2, if there's a federal law that allows the Illinois lawyer to do pro bono work in Florida, then Illinois can do pro bono work in Florida. For 9.4, while representing your employer in Florida, you engage in fraudulent conduct in connection to the transactional matter you're handling with your employer. Can you be disciplined in Illinois for the fraud? Florida, both. Obviously, both. 5.5A is you can be disciplined in Illinois. 5.5A second sentence, and 5.5B 1 and 2, you can be disciplined in Florida. Which professional rules will apply if you are disciplined? It's the state where the wrongdoing happened, we learned. Part 4, liability for lawyering activities. Yeah, you can refer clients to other lawyers, but you can't get a kickback referral fee. If you're a general practitioner, you fail to refer to a specialist when you should have referred to a specialist, then the legal malpractice lawsuit, you'll be held to the standard of a specialist. Lawyer has a duty to tell the client when they committed malpractice. This comes from case law rather than professional rules. This makes sense because you owe a duty of loyalty to your client. Also, the lawyers have a duty to communicate with client. Model Rule 1.8, if you settle your malpractice case, you must give the client in writing that it's desirable for them to seek independent counsel. Elements of a malpractice claim: state tort law claim can be derived from common law. There's one, duty of care that exists. Two, lawyer breach duty of care. Three, there's causation for actual injury. So under the duty of care for case law, lawyers must know the basics that other lawyers know, and lawyers must discover additional principles that are known by well-known lawyers. Competence standard is usually shown through expert testimony. Under causation, that's going to be a preponderance of the evidence standard. Note, model rule is not meant to be a basis for civil tort liability. Instead, model rule is meant to be a standard for professional discipline. So we're not going to look to the model rules for that tort, malpractice tort. Instead, it's going to be the 4 elements: duty of care, breach, causation, actual injury. So another hypo is you provide an opinion letter to your brother-in-law to the bank. Brother-in-law is trying to get a loan from the bank. Bank says, let's get an opinion letter. You provide it. As a lawyer, you lied and said you searched for liens where none existed. Turns out the brother-in-law definitely had liens and the brother-in-law defaulted. Here, the bank can definitely sue you for malpractice, even though the bank isn't your client. But the primary purpose of the lawyer-client relationship there was to influence the non-client. Here's the bank. Here, the lawyer, you in this hypothetical, made false statements of material fact. False statement of material fact was knowingly made. False statement was made for the third party non-client to rely on it. So all elements here for the bank non-client to have a tort claim against the lawyer for malpractice. Whether lawyer committed wrongdoing falls into 2 categories: 1, things outside of lawyering, and 2, things while acting as a lawyer. I don't know about that. Yeah, so things outside of lawyering, like you robbing a bank, things happening while a lawyer, things that are plainly illegal under criminal law and professional rules, a lawyer stealing client funds, sharing documents that the court ordered you to produce. Part of the lawyer's job turns out to be illegal, advising a company to adhere to normal document retention practices, but knowingly that will destroy key evidence. Hypothetical for part 4B, it's as follows. So for the hypotheticals, situation 1, partner hands you a new associate a list of foreign jurisdictions, all with favorable climates, asks you to prepare a memo for client on the extradition policy for each country, particularly the policies of extradition to the U.S., persons accused of security fraud violations in the U.S. If you prepare a memo as requested, you would be subject to potential discipline for prohibited assistance. You should be on notice that someone is looking to hide out, so this should set off some alarm bells. Taking all this together, it sounds like someone is asking you to help them flee. Would writing a general memo be a violation? That depends on the circumstances. So situation 2, prospective client says he operates a social club whose members are often harassed by police for playing small stakes poker and quote things like that. He offers you $500 retainer to be available if necessary to post bail or otherwise arrange to release of members who may be arrested. May you agree to this representation? 1.2 comment 12 says you may take criminal defense incident to a general retainer for a legal service for any lawful enterprise. So I would want to do a bit of investigation on how legal the social club is. If it's an unsanctioned gambling ring, which it sounds like it is, then I might not want to agree to representation. So remedy for incompetent assistance of counsel, it's a violation of the Sixth Amendment, damages a new trial, it's not monetary damages to the government, i.e. not the convicted person's lawyer. That's the defendant in the Sixth Amendment. If ineffective assistance of counsel. Strickland of Washington says there's two prong for criminal defendants: ineffective assistance of counsel. One's the performance prong, two's the prejudice prong. Defense lawyer conduct fell below an objective standard or reasonably effective assistance of counsel, considering all the circumstances, measured by the prevailing party's norms. Judicial scrutiny of counsel's performance must be highly deferential, stating the strong presumption that counsel's performance is reasonable. Prejudice prong, there's a reasonable probability that but for the unprofessional errors, the result of the proceeding would have been different. Reasonable probability is probability sufficient to undermine confidence in the outcome. Performance prong. If the counsel made an informed decision, the reviewing court is rarely going to find it to be ineffective assistance of counsel. So, for example, say a defense lawyer intervened alibi witnesses, decides they lack credibility, and decides not to call them at trial. Under the current standard in Strickland, it's highly unlikely that the court will find that lawyer's performance fails. But put another way, under Strickland, it's unlikely the criminal defendant claimant would succeed under an affirmative informed action made by a lawyer. Instead, the errors of omission by a lawyer that will serve as successful Sixth Amendment claims usually. So under the prejudice prong, is that satisfied if there's a reasonable probability, but for the professional errors, the result of the proceeding would have been different. Notice the performance prong and prejudice prongs are conjunctive, so you will need both criminal convict to win a Sixth Amendment ineffective assistance of counsel claim. So going to 5. Forming a lawyer-client relationship. Relationship is formed when a client reasonably believes they receive legal advice, depending on whether the client reasonably believes they receive legal advice. We don't care at all about what lawyers think. It ends when the client says so, and the lawyer ends the relationship under 1.16. You can probably withdraw here under 1.16 B6. Representation has been made difficult by the client, and 1.16 B7 is general catch-all. Allocation of decision making between client and lawyer. So the client decides objections. The lawyer decides the means to accomplish client's objective. Decision on whether to settle is on the client, not the lawyer. In criminal cases, client decides whether to plead guilty, not guilty, whether to waive a jury trial, whether the client will testify. Client decides when to settle unless client expressly gives the decision making power to their agent, not the attorney. The lawyer's duty within the attorney-client relationship, duty in the lawyer-client relationship, the duty of loyalty, duty of confidentiality, duty of confidence, duty of diligence, duty of communication, duty to give candid advice. Obviously, duty to charge only proper, reasonable fees. The lawyers are selling their time. With that being said, it's perfectly fine for a lawyer to be paid a retainer and not end up performing any legal services. There's two types of retainers. There's a general retainer paid to the lawyer solely for the lawyer's promise to be available when needed. It just buys promise of availability. The fee is earned when the promise of availability is made up front. Special retainer client pays money up front. As the lawyer earns the money, they perform legal services. 6, conflicts of interest. Concurrent conflicts of interest is 1.7. The conflict with your client, another client, or another person that can be in writing, can be waived in writing, and the other elements of 1.6b are met. 1.7, or I said 1.7b are met. 1.7a1, representing a client would be adverse to another client, like a lawyer acts adversely to a client in litigation, like cross-examination. Lawyer undertakes adversarial negotiations against another client. 1.7a2, it was an obligation to one client and competing obligation to another client, former client, the lawyer themselves. Hypo, the facts are that a firm is representing a tort defendant, but also representing the defendant's husband in a divorce case. Answer, it's not a concurrent conflict, but this is a concurrent conflict under 1.7a1. This is a non-consentable conflict since one party is making assertion against the other client in a divorce claim. You cannot represent both under 1.7b3. Most of the time you can think of A2 conflicts as a subset of A1 conflicts. 2 were injured in an accident. Now, We're going to B4. It's going to be our last part. Come on. Hypotheticals 1.9. Conflicts involving former clients. So whether someone is a former client is from the perspective of the firm. If related and material adverse, then we can't waive. Hypos for years. Number 1A, for years you've been representing a local company that deals with real estate, environmental matters. All prospective client worker meets with you, explains she was fired from a job at local because of her religious beliefs. Can you represent worker in discrimination against local? It's waivable, but employee needs to get different counsel for worker discrimination. Employer needs to get different counsel for work discrimination. Can't represent both sides of the V, obviously. Two, last real estate environment and environmental work you did was 3 years ago. Your bill for this matter has been paid. Didn't see any business since. Worker consults you about claim for religious discrimination she would like to bring against local. Can you represent worker in a discrimination action? Probably not substantially related, so 1.9C is relevant here, and you don't need consent from local. See, again, it's been 3 years and you have had any business from local group of homeowners living near local factory asked you to represent them in a nuisance lawsuit for locals polluting the water supply. Can you represent them? Definitely substantially related to the previous matter. So yes, new client would be material adverse. So you need informed consent from the previous client under 1.9A, and you'll need to get informed consent under 1.7. Under model rule 1.10, 1.7, conflicts are imputed to the rest of the firm.